Okay, let's keep rolling here in the equal rights chapter and lesson here. We're going to be on slide number 18 of the PowerPoint, talking about the Civil Rights Act of 1964. After a while, when you keep talking, it's amazing how quickly you get tongue-tied. So the Civil Rights Act of 1964 was an attempt to rectify what the 14th Amendment did not rectify. Okay, the 14th Amendment prohibits discrimination by government, but not by private parties. Okay, so in other words, private parties, private owners of businesses, okay, could discriminate, and did discriminate. Okay, so you're dealing with hotels, diners, gas stations, okay, things like that. So for the African American, we think nothing of traveling 500 miles, 1,000 miles for a road trip on vacation. Okay? Put yourself back into the life and the experience of the African American prior to the Civil Rights Act of 1964. You couldn't freely go from one gas station to another as you're driving because you might be turned away. So you can only go so far. Okay, so that's where the phrase there in the middle there on that PowerPoint, the public accommodation rights were not fungible. Okay, when something is fungible, it means it's replaceable. In other words, you can get a haircut at this barbershop and that barbershop and that barbershop, or you can go to this hotel or that. In other words, or diner. The idea that you can freely move about and enjoy the benefit of that service, you're not prevented from enjoying it. Okay, for the African American, they were prevented from enjoying certain restaurants and from enjoying certain gas stations and from enjoying certain hotels, okay? That's what it means where accommodations were not fungible, okay? When something ceases to be fungible, it means you can't get it at another place, okay? When something is fungible, it means that, you can freely get it wherever. You're not hindered at all, okay? And so the Civil Rights Act was passed. It was based on Congress's power to regulate commerce. And so the legislation entitles all persons to equal access to public accommodations. And it bars discriminations based on race, color, religion, sex, national origin in hiring, promotion, wages of employees in medium and large size firms. Okay? So it attempted to rectify that. Okay? Go to the next slide. Another attempt that was made to rectify discrimination, and this is more controversial, is something called affirmative action, okay? It's been around since the early 1960s. In fact, President Kennedy actually coined the phrase in Executive Order 10925. And he said that federal contractors need to take affirmative action, in other words, intentional steps, to ensure that applicants are treated equally without regard to race, color, religion, sex, or national origin, okay? And then several years later, President Johnson issued an executive order which required government contractors to take affirmative steps to expand job opportunities for minorities. And President Nixon went even further. He ordered federal agencies to set up a national minority business enterprise contracting program. Where this becomes controversial is it set up the quota system. Okay, it set up a system whereby employers, again, in this case, government employers, had to have a certain ratio or a quota or a percentage of employees, or in the case of students in schools, a certain number of students that are minorities, okay, to satisfy the requirements of affirmative action, okay? So if you go to slide number 20, it kind of explains it. I kind of just did, but let's just read it here. It refers to deliberate efforts to provide full and equal opportunities in employment, education, and other areas for members of the traditionally disadvantaged group. It applies only to organizations, okay, universities, agencies, and construction firms that receive, and there's the operative phrase, federal funds or contracts. If federal money is going toward that organization, it is subject to affirmative action requirements, okay? So these programs are required to establish programs designed to ensure that all applicants are treated fairly and bear a burden of proof. Again, that's where you get these quotas. Okay, so we'll talk about that in a second. We'll look at a Supreme Court decision that deals with this. But let's talk about the different types of discrimination, okay, that the Supreme Court has attempted to address, okay? There's something called de jure discrimination and de facto discrimination, okay? Those two phrases they're Latin if they seem unfamiliar to you. Actually, back in the day, it was required of students in high schools and colleges to actually take Latin. Okay. In many respects, I wish we could go back to that because it really helps you kind of disentangle some of these words. Okay, especially when you get into a lot of legal phrasing, they use lots of Latin, and so when I had constitutional law in grad school, I had to really kind of wrestle through that. But de jure discrimination is discrimination based on law and in state laws requiring black and white children to attend separate schools. Okay, or any type of discrimination. Okay, by law. De jure is by law. Okay, so if by law they're discriminated against the races, okay, the courts will step in and address it. But then there's something called de facto discrimination. Okay, and so de facto discrimination is not based on law, but based on fact. In other words, the law might say you can't discriminate, but discrimination is still happening. Okay, so by definition, this is the condition whereby historically disadvantaged groups have fewer opportunities and benefits because of prejudice and economic circumstances, such as their inability to pay for a college education. Okay, so again, under the logic of de facto discrimination, it's this idea that even though the law doesn't discriminate, by your circumstances or by the prejudices of individuals, you still are barred or separate or perhaps granted an inferior status, okay? And the court deals with that, okay? So de jure discrimination would be, I'm trying to think, okay, de jure discrimination would be Plessy versus Ferguson, okay? So in other words, in law, you had to discriminate between the races on train cars. De facto discrimination would be discrimination that happened, perhaps, let's just say, after the passage of Brown versus Board of Education, where there are still schools, particularly in the South, that still discriminated among the races after 1954. Yes. So in other words, the law says you can't, but it still was in practice occurring. That's an example of de facto discrimination. Okay, and by and large, attempts have been made to rectify that, okay, but it still can happen, okay? And so again, those are those two terms, those two legal terms, okay? So let's shift gears here and talk about a Supreme Court case that dealt with affirmative action, okay? And again, this is where the use of these two terms, de jure and de facto discrimination, kind of come into play. So in the University of California Regents versus Bakke, again, this is slide 22, basically this was the court's first attempt at addressing affirmative action. Okay, they were trying to see whether or not discrimination was taking place. In this case, this was a white individual that was applying to the University of California Medical School, okay? And because of his grade point, because of his test scores on the MCAT, which is the medical school test, he was, well above most. But because of the quota system that said that there was a certain percentage of minorities that had to be in the medical school, he was prevented. He was prevented not once, but a year later, he reapplied and was prevented again. So he sued, and it went before the Supreme Court. In other words, it's one thing to try to provide opportunities for minorities. It's another thing when perhaps reverse discrimination is taking place, and now individuals that would normally qualify and or exceed expectations because of their GPAs or their test scores. What do you do about them? Okay, and so the court basically decided for Bakke and said that it continued to affirm affirmative action, but it said that some steps need to be taken by universities to make it fair for whites as well. Okay, so here's here's how Justice Powell who was the justice on the case, argued, okay? And you can go to the next slide, that's slide 23. He said this: in summary, it is evident that the Davis Special Admissions Program, that's the medical program at the University of California, involves the use of an explicit racial classification never before countenanced by this court. It tells applicants who are not Negro, Asian, or Chicano that they are totally excluded from the specific percentage of the seats in entering a class. No matter how strong their qualifications, quantitative and extracurricular, including their own potential for contribution to educational diversity, they are never afforded the chance to compete with applicants from the preferred groups for the special admission seats. At the same time, the preferred applicants have the opportunity to compete for every seat in the class. Okay, so he's expressing this challenge. It's a conundrum, right? On one hand, you're trying to, affirmatively give some opportunities for minority groups. But then what about individuals that, in particular in Baki's case, his scores far exceeded most, okay? And he was barred. And so basically the court said affirmative action stands, but you still got to work this thing out, okay? While the Baki majority ruled in favor of the non-minority student, admissions programs could now use racial classifications if they are narrowly tailored and are just one of several factors in the attainment of a diverse student body, okay? This is something that the court tends to do, is that they try, in the case of affirmative action, or in the case of granting new rights to new classes or new groups of citizens, again, we're talking about equal rights, the court will try to narrowly tailor it so that on one hand, it gives the rights to the new class. But on the other hand, again, when it's narrow, it doesn't apply to everything, okay? So in this case, they said, listen, universities may, discriminate, if you will, against whites for the sake of affirmative action, but it's got to be narrowly done, okay? In other words, it's got to be one of several factors that you're determining students. In other words, you're determining perhaps a minority student, not just based on that quota, but just an example. What are they doing for the community? What kind of a character of a person they have? In other words, just because you're bumping them up because they got a 3.3 and not a 3.6 because of everyone else, okay? You can't just use that. You've got to look at, okay, are they a person of character? What have they done in the community? Are they helping out in the community? Or is all that they do studying? Okay, in other words, they're trying to look at a broad base and see if this person is more of a well-rounded individual to take that in, okay, to admit them. That would satisfy the narrowly tailored requirement, okay, that the court advocated, okay? That's that issue there, okay? I'm going to stop there and we'll continue with slide number 24 next.